Hello, everybody. Welcome to the Criminal Procedure Fourth Amendment Search and Seizure Essay Approach. Please take a moment and copy down the checklist on the board, and I'll be back in a few to begin the approach. Thanks. Okay, hopefully that gave you enough time to copy down the approach. Let's begin Fourth Amendment Search and Seizure. Now, Fourth Amendment Search and Seizure, I'm going to refer to it as search and seizure from this point forward, is an area on the California bar exam that gets tested frequently. This approach will get you through it, and it is predominantly all that you will need to know. So make sure that you really study this checklist. Obviously, refer to the long outline for more elaboration, especially on the exceptions to the warrant requirement and for the exclusionary rule and fruit of the poisonous tree. There's a little more cushion in the rules and the long outline for those areas, but the approach can get you through it rather well, and you don't have to spend too much time referencing the rules in the long outline. So let's begin, and I want you to make sure that you know this approach down and you have a good structure for it, because that's really where you could get lost and start missing points. So let's begin. Take out your approach. The first thing we're going to do is just merely quickly state the name of the item or the place being searched. Look at your approach. The first heading will always be what was searched or seized. State the following in some abbreviated format. Under the fourth, which is applicable to the states through the 14th Amendment, there can be no unreasonable search or seizure. In order for the government to bring a Fourth Amendment violation, there must be government conduct and standing. These are major issues that have a lot of points within them. They are major foundational requirements in order for a defendant to bring a charge under the Fourth Amendment. So we make a heading, government conduct. Do not miss this issue. Do not miss this issue. Now, government conduct, when we get into confessions, I have a little subnote here of informant, just because I want you to start thinking about when an informant can take the place of government conduct. Not very relevant for Fourth Amendment, but it will be relevant for confessions. Now, government conduct is something that you'll probably get rather quickly in and out of and not spend too much time. If you look at your approach, the rule is the unreasonable search or seizure must have been conducted by someone working for the government. Working for the government. So that's usually established. You can establish it and move on. Your analysis will be rather short here. However, standing, another area that has a lot of points, and these areas, government conduct and standing, could be 10-point issues each. They could really break your score range. So make sure that you hit them. They're very commonly missed issues, and I'm telling you, discuss them every time. Always Fourth Amendment search and seizure is at issue. When you get to standing, there has to be a reasonable expectation of privacy in the place searched or the item seized. A reasonable expectation of privacy. Now, it's an ordinary standard. It's a place where one would have a reasonable expectation of that privacy and really establish it. Don't just say that the defendant had an expectation of privacy in their car because they were inside it. Give a little bit more elaboration. This is where you can give some creative inferences. Why would someone believe that they have a right to privacy in a place like a car or a home? Obviously, those places exposed to the public, one will have less of a degree of an expectation of privacy. Now, in your long outline, this is a place I want you to reference. It's not within the approach, where it does elaborate on where the Supreme Court has held that a defendant will have, a criminal defendant, will have that reasonable expectation of privacy. I don't necessarily want you to memorize those areas, but you should be able to identify them and determine whether or not that is a place that a person would have that degree of privacy expectation. So make sure you know them, and again, elaborate on this issue. It could be a major issue, especially if it's a murky one. Maybe it's not very clear as to whether one would have that expectation of privacy. Maybe it's a passenger in a car. Really give some meat on the bones here in your analysis. Okay, so always government conduct and always standing. Now, where do we go from here? A lot of applicants will just jump right into the warrant exceptions. But the first thing I want you to do always is establish whether or not the fact pattern is actually giving you a warrant. Whether it's valid or not, at this point we don't care. We just want to know, is there actually a warrant? So you make a heading, warrant. Now, if there is, this is very important, if there is a warrant, you're going to go into the three-part test as to the validity of the warrant. So go to your approach. A valid warrant requires probable cause, that seizable evidence would be found in the place or person searched, a valid affidavit that is precise on its face. Probable cause exists when the facts and circumstances within the arresting officer's knowledge are sufficient to warrant a prudent person to believe that a suspect has committed, is committing, or is about to commit a crime. Make sure that you know that. That is very, very important. Things to consider for probable cause: was there an unreasonable delay? Was there an informant? And was the tip reliable? No, a reasonable belief that a person has committed a crime will suffice for probable cause. This is really the major issue with the validity of a warrant, probable cause. So take a little time here, give a really good analysis, and establish whether or not probable cause existed. A valid affidavit, they may not give you enough facts as to this, so you can say assuming that the affidavit was valid, but there must be an affidavit to a neutral and detached magistrate. Again, they may not give you enough facts for that. So quickly get in and out of there. Precise on its face. The warrant must describe with particularity the place to be searched and or the items to be seized. This is somewhere where they could give you enough facts. Maybe you don't have that precision, but even if you don't, you still will not stop here and you will continue on your approach. So precise on its face and probable cause as your major two factors here. But again, you want to establish the validity of the warrant, but you don't want to spend so much time here because you're still, even if you have a valid warrant, going to get to your exceptions. Your exceptions are going to back you up regardless to tell the graders, even if even though some of these elements for a valid warrant are met or all of them, I'm still going to give you any potential exceptions that can apply. We're always going to back ourselves up just in case. You're never going to have a Fourth Amendment essay where you stop at the validity of the warrant. You're always going to keep going into any potential exceptions. Now that's scenario one. Scenario 2 is if you don't have a warrant. If there is no warrant, you still, after standing, will make a heading warrant, and you're just going to tell the graders the following. Here, because the facts do not state anything as to a warrant being present, here, because the facts do not state anything as to a warrant being present, unless a warrant exception applies, the item will be inadmissible under the Fourth Amendment. Unless a warrant exception applies, the item will be inadmissible under the Fourth Amendment. And you will go right into, in that scenario, the warrant exceptions. So again, 2 scenarios. Always government conduct and always standing. Always go into a heading warrant. Scenario 1, if you have a warrant, establish the 3-part test for a warrant, separate IRACs for each one, really go into probable cause and precision on its face. Quickly get in and out of valid affidavit, and then still go right to the warrant exceptions. If there is not a warrant, you still government conduct standing, whether or not you have a warrant, okay? Give that transition paragraph I just gave you and go again right into your exceptions. Okay, so now in either scenario, we are here in our exceptions. You're on the lookout always for at least 4 to 6 exceptions. Exceptions are heavily tested. This is the main area where applicants will lose points. So if you miss a couple of warrant exceptions, even if you do great on a couple of others, you can definitely not pass your essay. So make sure that you're doing, if this is an area that has been tricky for you, make sure you're doing, or even if not, you want to really do some good issue spotting here, to make sure that you have really exposed yourself to all the different types of warrant exceptions, because they all get tested equally. So it's not like any of them get tested more than the others. Now, 1, 2, 3, 4, 5, 6, 7, 8. So there are 8 main exceptions. You should know that number. And what are they? Now, I've given them to you in your approach. Of course, the long outline will elaborate on these exceptions. Make sure you know them really well. So we have the automobile exception. That is the first one. States may allow the warrantless search of an automobile if the police officer reasonably believes that the vehicle holds evidence of a crime. The U.S. Supreme Court has determined that this exception is not a violation of the Fourth, since drivers have a reduced expectation of privacy and a vehicle is inherently mobile. So this is a huge exception that comes up in the context of car searches. The big question always is whether or not within an automobile exception, the police can search the trunk. And the answer is yes. So if you go to your approach about 3 bullet points down, the scope of the search is limited to only what area the officer has probable cause to search. This area, again, the police have to have probable cause to search, and if they do, they can search the entire car, including the trunk. This area can encompass the entire vehicle, including the trunk. The exception, in addition to allowing officers to search the vehicle, also allows officers to search containers. That comes up a lot on essay fact patterns here, found inside the vehicle that could contain the evidence or contraband being searched for. The objects searched do not need to belong to the owner of the vehicle, so passenger items as well can be searched. Passenger containers can be searched here as well. This is a major exception. Make sure that you know it. The next exception, which also comes up a lot within the context of a car, is search incident to arrest. Search incident to arrest is kind of tricky because there's 2 main types of searches that could fall within this exception. The first one, let's stick within the gamut of a car search, okay, is when a police officer or when the police have probable cause, they stop the car, let's say for speeding, and then the actual driver, let's say, is getting searched for contraband or whatever it is based on probable cause as well. And the driver comes out of the car and they get arrested because there's probable cause to arrest. Now, incident to that search, to that arrest, there was a search. And there is a specific rule, it's pretty new, it's like 4 or 5 years old, that changed the contemporaneous in place and time standard. Now, to be clear, the contemporaneous in place and time standard that I'm sure most of you learned in law school, that still applies to the search of a home. So that's the second, or anything outside the context of a car. So that's the second type of search that could come up within search incident to arrest. Let's take a look to clarify what I'm talking about. If you go to your approach, search incident to arrest, it says A, the test for searches in the context of a car. So this test, okay, and this is US v. Gant. You don't need to know case names, but the old rule that you may recognize from law school was Belton. And under Belton, we had the contemporaneous in place and time standard. But under Gant, we have a new rule for search incident to arrest within the context, again, of only a car search incident to arrest. So make sure you know that discrepancy. No more contemporaneous in place and time within search incident to arrest within the context of a car search. So the first thing you need to establish under Gant is a heading, lawful arrest. I'll just kind of put it right over here. Your first is a lawful arrest. We know that's one that needs to be done with probable cause. Next, police can search a car following a lawful arrest only if they have reasonable belief that the person arrested could have accessed his car at the time of the search. So unsecured and within reaching distance. Now, a lot of applicants go, and including myself, and including a lot of my lawyer, criminal defense attorneys, or prosecutor friends go, what do you mean unsecured? How can a defendant be unsecured? Search incident to arrest. They're arrested next to the car, the cop car, and incident to that arrest, they're going to be searched. But the standard says that they have to be unsecured. So what does that mean? Well, what we've determined is basically that means that they still could, maybe with their feet, pound on some contraband, get rid of some evidence, and maybe even try and escape. So that's where the unsecured analysis will come in, but I still understand it's kind of tricky. Sometimes on the bar, we just have to accept the law for what it is, deal with it the best that we can, make a good analysis, and move on. Don't get caught up in this. So back to our approach for search incident to arrest under Gant, we need a lawful arrest, and the defendant is unsecured and within reaching distance, or the search is for evidence related to the arrest. So that's another way, so it's an or standard. The police can search the car for evidence of the offense for which the defendant was arrested. Now that makes a lot more sense. And hopefully that's what they give you on your fact pattern. It's probably going to apply every time. I would always consider both ways under this Gant standard to get potentially the exception to apply. So unsecured and search for evidence, search for evidence related to the arrest. Now I've given you a lot of notes here, a lot of clarity on this Gant standard. Read through it. I know that it will make it clear for you as to exactly what the Supreme Court was getting at. Now remember, that is in regards to searches. I know I've said it like 5 times now, searches in regards to a car. But what about search incident to arrest in regards to anything outside the context of a car, mainly like in someone's home or maybe on the sidewalk? So then we stick to the old standard. If you go to your approach, in order for the police to search incident to arrest, the search must be contemporaneous in place and time to the arrest. The rule for search incident to arrest in relation to a search on a person and not a vehicle is that an officer may perform a warrantless search during or immediately after a lawful arrest. This is the important part. This search is limited to only the person arrested and the area immediately surrounding the person. The area immediately surrounding the person. So that's what contemporaneous in place and time means. Make sure in your analysis you're really going into, is it within the scope? Is it right around that person's kind of area? If it's outside that scope, it may not be contemporaneous in place and time. So we've gone through automobile, we've gone through search incident to arrest. We have 6 other exceptions. Again, there's a lot of rules as to the exceptions, especially when it comes to consent. Consent has 4 or 5 different people that potentially can consent. Children, roommates is a hot one, parents is a hot one. Make sure you know all the different forms of consent that could apply. Inventory searches comes up a lot. Plain view is one that I want you to always consider. It's kind of like a fallback. It comes up almost every time. So make sure that you take note of the plain view exception. We also have border searches and stop and frisk. Stop and frisk I want to clarify something on. So if you can turn to your approach to that section. Police may stop a suspect so long as there is a reasonable suspicion of a criminal act. The evidence necessary for reasonable suspicion. So this is the first time right now that we're seeing reasonable suspicion as opposed to that probable cause standard. It's a lesser standard, right? Here there is something beyond mere suspicion, but is less than the level required for probable cause. If there is reason to believe that the person may be armed and dangerous, that is really important. Armed and dangerous, the police can also frisk the suspect. So we have a pat down, let's say, for example, going on. The officers believe by plain feel that they feel a gun. Now, this is not contraband. There has to be this armed and dangerous, kind of state of mind that goes in where it's like, ooh, I feel like a weapon. Then it rises to the level of probable cause, and the officer now can can frisk the actual defendant and remove the gun or whatever weapon they find. So that is what stop and frisk is. So we start with reasonable suspicion, which then rises to the level when that armed and dangerous standard is met, where the police can now frisk and actually take out the gun or the weapon. And exigent circumstances, always consider this one as well. It's a good fallback provision and exception also. So just to reiterate, we have government conduct, standing, warrant requirement with 3 different prongs. If you don't have a warrant in your fact pattern, get quickly out of that. Tell the graders there is no warrant and therefore an exception must apply, and get into the exceptions. If you do have a warrant, go through 3 separate IRACs on the requirements for a warrant and get into your exceptions. We went into the automobile exception, search incident to arrest, inventory search, plain view, consent, border searches, stop and frisk, and exigent circumstances. Now you're not done. What was the point of you being here in the first place? The point of you writing for Fourth Amendment is to determine, is the item going to come in or be excluded? So you make a heading always at the end, exclusionary rule. Always at the end, you will make a heading exclusionary rule, and you're going to determine whether or not, based on the above, if an exception applies, and remember, you only need one, the item will come in. So don't forget to put a heading exclusionary rule. Now, you may see some versions out there or templates out there where people recommend to start with the exclusionary rule, but that doesn't really make a lot of sense, because we can't really determine at the beginning of an essay whether or not the evidence should come in until we take it through these hurdles. Now, there are exceptions to the exclusionary rule. Good faith is a main one, and there are other ones within your long outline. Please know them. Don't miss them. And then impeachment is basically, if it can't come in under the 4th, to be against the defendant, maybe it can come in to impeach him or her. So this is just like some extra brownie points. We see it in a lot of model answers here in California. Now, you're still not done. Well, you could be done, but I want you to consider just 2 or 3 more things. A lot of times on the exam, in a 4th fact pattern, we have fruit evidence, which is fruit of the poisonous tree. So I want you to consider at the end whether or not you have any fruit evidence. Now, what is fruit evidence? Let's go to your approach. If the exclusionary rule applies, all evidence obtained as a result of the illegal search and seizure will also be excluded. However, there are exceptions where the fruit of the poisonous tree evidence may still be admitted. So anything that comes off of, like a confession or something else, another item of evidence that comes off of the illegal search will also be excluded, and you must identify that as fruit evidence. You have to make a heading and identify it as fruit evidence. Now, there are exceptions, again, just like we have exceptions to the exclusionary rule, inevitable discovery, intervening acts, and violations of Miranda. There are, again, more elaborate exceptions under your long outline. You can take a look at that and make sure that you know them for clarity. And if they come up, do not miss the exceptions to the fruit of the poisonous tree doctrine if it is at issue. Now, sometimes the last little sub-issue that could come up here is, let's say a question, maybe it's like the third call, it's a very minor call at the end of your fact pattern calls, asks on appeal what result. So now maybe the item was let in and the criminal defendant has appealed to say there was an error below in the below court because the evidence should not have been allowed in under my Fourth Amendment rights. What is the standard that the appeals court will review that admissibility? Well, if you go to your approach, and again, this is a minor issue that comes up, but if you ever see in the call on appeal what happens here, they're asking for the harmless error test. So you would just make a heading and state the following. If the illegal evidence is admitted and results in conviction, on appeal it should be overturned unless the prosecution can show harmless error, which is measured by beyond a reasonable doubt standard. Beyond a reasonable doubt standard. So that is your issue. If they're asking for on appeal by the defendant, what happens? It's harmless error as your sub-issue. So this area, now that we've concluded, this area of the law can, especially to write for, can be a little bit of a racehorse, especially if you have a lot of exceptions to get into. So issue spotting technique, making sure that you do definitely a few criminal procedure Fourth Amendment writing exercises, and really hashing out and writing out within the gamut of this approach is going to be fundamental for hitting your issues, hitting your exceptions, hitting the exclusionary rule and any potential exceptions, considering any fruit evidence, and then maybe you'll have a sub-issue on harmless error. It's 50-50 there. That doesn't come up very frequently. I wish you the best of luck if this does come up. Know this approach well, and on to the next.